The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Good morning. Court Radio is now in session. Call 215-227-2727. When you've got legal questions, we've got the answers. This is Court Radio. And now here's your host, Dean Weitzman.
Good morning and welcome. It's Court Radio, and I'm Dean Weitzman, joined in the studio with the special co-host, the one and only Jeffrey Gross.
Good morning.
Yeah, your adoring fans love you. When Jeff's in the studio, we're talking workers' compensation. So listen, if you've been injured on the job, if you've got a work-related dilemma and it involves an injury, Jeff probably has handled that case. How many cases have you handled in workers' comp?
A real lot.
A real lot.
I mean, lots.
You've been practicing for how long?
About 26 years now.
Okay. Yeah. More than 1,000.
Oh, yeah.
More than 10,000.
Probably.
Of course.
Of course.
All right. Well, listen, if you want to ask your legal questions, whether it's workers' comp or any other issues, Jeff and I will take our best shot at it. All you got to do is give us a call at 215-227-2727. That's the number you need for all your legal issues, 215-227-2727. Jeffrey, in the news right now is a groundswelling of requests and demands for the ouster, for the resignation of Pennsylvania Supreme Court Justice Michael Eakin. He is the latest Supreme Court justice to fall under the hammer for literally thousands of inappropriate, pornographic, racist, sexist emails that he sent to his buddies. A lot of them were, prosecutors around the state. And so the question arises, is it becoming behavior for a Supreme Court justice? Of course not. But does it demonstrate that he has an inability to be fair to those very people that he has to make decisions about on their cases when he's laughing at them through the side of his mouth to the people who are prosecuting them?
I think it demonstrates the ability for our system to function as best as it can. There are checks and balances in our system, and this is one of them that works, where when a person acts untoward and creates issues and should not be there, that the system has a checks and balances system that will knock them out. And this is a good example of it. Yeah,
I would take a bet that Supreme Court Justice Michael Eakin isn't there in, 3 months. That's my guess. Judges have a duty to act with impartiality. They can't even have the appearance of partiality.
That's right. And in fact, the workers' compensation system is a judge-determined system as opposed to a jury-based system. So all of the cases that you bring are before a judge that you get assigned to.
And that judge, you need to have confidence that that judge will give your clients a fair shake. They'll listen to the evidence and with impartiality decide the dispute.
Right.
And for the most part, that works.
Right. And what's most interesting about this whole thing is that the Supreme Court is at a much higher level. I mean, you'll never come into contact with them most likely, right?
Yeah.
Unless you're appealing and appealing and appealing and appealing. By the time you get there, you probably, people don't see the Supreme Court. People see the underlying judges.
Right, the trial court.
Exactly. So,
it seems to me, have you ever come across a judge in your practice that you felt just never gave a claimant a fair shot?
Of course.
Really?
There was one in particular in the 1990s, early 1990s, that was so bad that you knew you were going to lose. There was one attorney that went before him and started acting completely ridiculous in order to get a recusal, meaning in order to get removed from that judge so he would no longer have to practice in front of that judge by showing that the judge disliked him. And the way he did that was he basically cursed at the judge every time he saw him. And he said, Judge, I'm motioning for recusal. You can't treat my cases with impartiality because you don't like me. It was a very interesting move.
Did it work?
Well, he actually got sanctioned.
The lawyer got sanctioned.
The lawyer got sanctioned.
What happened to the judge?
Well, the judge actually retired because he was older anyway, but the judge didn't get admonished. That's the judge's views. I mean, people are people, right? So people are going to make decisions. You want to just make sure that you elect and get appointed and put pressure on the powers that be in order to get the appropriate judges in there. That's why voting is so important. That's why getting out there and supporting the right people is so important.
Well, how do workers' comp judges get to be judges?
Workers' comp judges are appointed by the governor and by the state, and they actually take an exam, and there's a committee that reviews the exam. They have to score a certain level, and then they get interviewed by the person who is the director of adjudication at the time, and that person will make a recommendations, and then they're appointed.
I see. All right. Well, suffice to say that you practice in the workers' comp arena only, right? You and in that arena, you know the people that you have to advocate in front of.
Correct. We know the people we need to support. We know the judges we need to push to get in. We know all the judges. I mean, I've been doing this for 26 years. I know all the judges.
Right. And even judges not right in the Philadelphia area. You practice workers' compensation. It is a statewide practice.
Correct. I mean, most of what I do is regional within the 5 counties or 6 counties surrounding Philadelphia, including Philadelphia, but also statewide. I've taken cases in the western part of the state and the northern part of the state.
Come on, listen. You fly airplanes.
That's true.
As an avocation, you've flown to hearings all over the state.
That's very true. One time I flew to Altoona, and I represented a nice man who was totally disabled, and that was a very interesting experience because when it came time to the hearing, it snowed. I had to drive there. It was not a good thing.
215-227-2727. You got legal issues. Jeff and I will give you the answers. Let's talk to Brian from Lawnside, New Jersey. He's got a workplace injury question. Hey, Brian, welcome to Court Radio. First-time caller?
Yeah.
Listen, bud, I want you to stay on the line after Jeff answers your question, and Monica's going to get you a T-shirt for your troubles, okay?
All right.
All right, so what's your question?
My question is, I was injured on a job about a year ago, and I can't return to work because I'm not fit for duty. So I had to put in for medical retirement. So my doctor told me that in the future that I'm going to have a lot of restrictions, and, I'm partially disabled in my right leg. I'm 49 years old, so am I eligible for Social Security disability?
Okay, well, first off, how did you get injured?
I slipped and fell on the ice.
While you were working? While you were working?
Yeah.
Yes.
Yes, I was reporting to my post.
Okay, and are you currently obtaining workers' compensation on a weekly or biweekly basis, or is that matter now settled and resolved?
No, I'm still receiving workers' comp.
Okay, let me jump in. A couple things here. First of all, you have to be very careful because if you put in for a retirement, that means you're taking yourself out of the workforce. And this is an interesting concept because if you take yourself out of the workforce, that means you're not entitled to workers' compensation. You understand that workers' compensation is for people who would otherwise be working and can no longer work as a result of an injury. If you retire from the position and you declare yourself retired, you're basically saying, I am out of the workforce. So you have to be very careful with that. It has to be a retirement. You have to show that you are disabled, and it must be a disability retirement as opposed to a pension retirement, number one. And number two, your question about Social Security, you are eligible for Social Security. So let me give you some practical advice about that. You said this injury happened about a year ago. That's usually when you would make the application, depending on a couple of circumstances. But generally speaking, Social Security is retroactive 1 year from the date of your application. So if you are disabled in 2014 and you make application 2015, it's retroactive to the date that you were injured, so long as it doesn't exceed 1 year. Social Security is harder to prove than workers' compensation. You have to be totally disabled from most all employment, whereas workers' compensation, you need to be disabled from your time of injury position, which is a completely different burden. So you have to be careful. I would, if you want, you can give me a call. I'd be happy to talk to you offline and give you the nuances as far as that is concerned.
Brian? All right. Maybe Brian was so enamored with your answer, Jeff, that he just he had to let the phone go. All right, Brian, if you want to get in touch with Jeff, all you got to do is give us a call at My Philly Lawyer, 215-227-2727. We'll get you right over to Jeff's cell phone. Jeff gives his cell phone out to clients. Get out of here, Dean. You got to be kidding me.
I'm
Stop
crazy.
It. Really?
I'm crazy.
Yeah. Folks, if you don't have a lawyer that hands out his cell phone on workers' compensation cases, then maybe you should think about Jeff Gross on your next workers' comp claim, because he hands his cell phone out to every single client, and he's available most of the time, except when he's watching the Flyers lose.
Yeah, that's not a good thing. That was a bad game last night, I got to tell you.
Really?
Yeah, horrible. 4-1. Woo. Not good. Against the Columbus Blue Jackets. Not good.
Yeah, well, when I was watching hockey back in the 70s, I don't think there was a Columbus Blue Jackets.
No, that's a relatively new team. But interestingly, I did get a lot of texts from clients during the game, even though I was there, and I did respond because I encourage my clients to call me or text me on my cell phone only because I want to be there for them. I want to answer their questions. It's very important that communication is kept and open.
One of the biggest complaints about clients and lawyers that's my lawyer doesn't call me back. And in this day and age, that's just unforgivable. At My Philly Lawyer, we have a answering service 24/7. I get in real time emails with clients' concerns and inquiries. I funnel those to people who can answer those questions in real time. And that's just the way of the world today, you know?
It's true.
This idea that, you leave the office at 5 o'clock and go home and you're not available again until 9 the next morning is insanity. If that's what your lawyer's doing, that's probably not the right standard today.
You're going to see doctors starting to do that too.
Yeah. I mean, why shouldn't you? I mean, we're professionals, but we're making a good living, and our clients depend upon us, and we should be there for them whenever they need us. 215-227-2727. You got legal issues. We got the answers. Let me talk to Cynthia from North Philly, who has a car accident. Cynthia?
Hello.
Hi.
Hi.
How are you?
I'm well. How are you?
Good. What are you doing up so early?
On my way in from work. Early riser.
There you go.
But thank you for taking my call first. And to kind of give you background, this is for my husband's case. 3 years ago, he was involved in an accident on SEPTA. Another car hit SEPTA. We wind up settling on September 1st. Both insurances had to pay out. Now it's December. We still don't have our settlement, and it's because when the lawyer went to go, issue the papers for subrogation and stuff, he found out that the hospital had put the entire balance, like a lien for $82,000 against our case. Now we have to get another lawyer to sue the hospital to lift that lien because it's in collections and everything. Yep. So my question is, was my lawyer was his lawyer at fault? Because I feel like he should have foreseen that coming.
Well, okay, it's possible that, he could have known about this potential pitfall early in the process and handled it more efficiently. That's a possibility. And, I'd have to see all the paperwork to see it. But then the question is, okay, well, what's the damage? The damage is that you're waiting longer for your money. But
Right.
At the end of the day, if it's now handled properly, you'll probably get all that you would have gotten even if he had handled it earlier. The question is, you mentioned the word subrogation, and I just want to explain to our listeners what that is. There are times when an insurance company, whether it's a workers' comp company or a health insurance company, pays out a benefit to their insured. They pay out for medical expenses. And then the case settles against the at-fault parties. That's the bad people, the people who caused the accident. Well, these companies, the workers' comp and or health insurance company, can reach into the settlement against the at-fault parties and take their money back. All of it sometimes, or some of it sometimes, depending. And this is an everyday event. It wasn't like that when I started practicing and when Jeff started practicing. But today, we're constantly dealing with liens of one sort or another.
For workers' compensation liens, they're absolute, meaning their right of subrogation is absolute. They can get their money back when people are successful against a third party. However, usually we can negotiate that lien as part of a global settlement. And what I like to do is I like to get in there early and explain to the workers' compensation carrier that if the trial is lost and we don't settle, then they're not going to get repaid a dime. So we have leverage by showing the level of participation and the strength of the third-party claim against the bad people, as Dean said, in order to get some kind of leverage to reduce the workers' compensation lien.
And to give a real-world example, I just settled a case in New Jersey for $500,000 that involved a workers' comp case. In other words, the person was injured in a car accident, but while working. We brought a claim against the at-fault person who caused the accident, and that case resolved for $500,000. But the client had been receiving workers' comp all along, and the comp claim had a $193,000 lien. They wanted to be paid back. Even after the reduction, they wanted to be paid back $193,000. There was not enough money to satisfy my client, the comp carrier, and so we entered into further negotiations, and the comp carrier eventually accepted $130,000. The client ended up with over $200,000, and everybody was happier because of those, last-minute negotiations. Now, Cynthia, on your husband, his case, did it involve a work-related injury?
No.
Okay. So the lien is just from the health insurance carrier?
No, it's from the hospital, actually. And, see, we don't mind paying the insurance back. Out of $83,000, insurance paid out $4,000. You know how they negotiate the rates and all that. We don't mind paying the $4,000, but and they accepted the payment as in full. So how is it that they're balance billing us for the full amount, and then now it's a battle to a point where we have to get another lawyer?
Well, here's the possible answer to that. And I'm again, without seeing all the paperwork, I can't tell you for sure, but there's most of the time you're right. A hospital or a doctor will bill you a certain amount for an auto accident, and then under an act in Pennsylvania called Act 6, that bill is reduced to a very small percentage usually of the full amount. There's one exception, and that's when you have a hospitalization that's deemed trauma-related. When somebody goes into a hospital for a trauma, that's where it's life-threatening, then... And in that circumstance, they can bill and be paid 100% of their bill. Now, maybe the hospital's trying to claim that this is trauma-related, and they were entitled to all of it, even though the insurance company only sent them $4,000. That's one possibility, and it's also more likely, Cynthia, that the hospital screwed up and their billing department has it wrong, because more times than not, that's what I see. And so at the end of the day, what I'm hoping for you, Cynthia, is that the hospital acknowledges that they got paid all that they're supposed to be paid, and they're not looking for any more.
Right.
But it's going to take... You're right. It's going to take some time to tease this out. And I wouldn't be surprised if you were still talking about this in 2 or 3 months.
Oh, don't say that.
Cynthia, thanks for calling Court Radio, and have a great Sunday.
Thank you. You too. Have a good holiday.
Bye now. All right, let's talk to Timothy from Logan, who's got a workers' comp question. Yo, Tim, welcome to Court Radio.
Thank you. Good morning, and glad to talk to you, gentlemen.
Good to have you, bud. So what's your question for Jeff?
My wife was injured on the job. She's a federal employee, walked into one of the bathrooms to go into the bathroom. Water was all over the floor. As soon as she stepped in, fell, hurt her ankle, her thigh, and her back, trying to catch herself before she hit the floor. She was out of work for 2 to 3 months, filed all of her paperwork for workers' comp. They denied her. And she then started, the process of talking to her doctor again, him resubmitting the paper, and she hasn't heard anything. No medical has been done. Her ankle is still hurt. She can't really walk, but yet she had to return to work we got to keep bills paid. What do we do?
Well,
that's a tough one.
Let me just ask you one question real quick. Does she have a lawyer?
No, we need one. And now that's what I'm realizing. That's why when I heard you guys, I just called you right away.
Yeah, it befuddles me how anybody, and I don't mean to, you're just an example right now, sir, but I have to use you as my example. How anybody could be involved in a claim for 3 months and not have representation is hard to fathom. Because even, I got to say that insurance companies, adjusters, that whole claims process is not designed to be good and nice and helpful to the claimant. Okay, it's designed to pay as little as possible and get them off the books as quickly as possible. And the only way people get what they're due is when they have somebody who's smart enough and has experience enough to advocate for them. And so any potential claimant who goes forward on their own, more times than not, doesn't get what they deserve. The only way you get what you deserve is when you have competent representation. You don't. And it doesn't surprise me that she's chasing her tail for 3 months. Here's the difficult thing. She's a federal employee. And, Jeff, you're going to comment on that.
I am. There's a big difference between federal and state employees, meaning people who work for private companies that are governed under the state law. That's workers' compensation. Federal workers' compensation is governed by the federal government. So your wife was an employee of what agency?
The IRS.
The IRS. So the Internal Revenue Service fits under the federal government, and you're right, she's a federal employee. So she has to go through the federal workers' compensation program, which, again, is different from the state. What should be done is there has to be a claim petition filed, and the filing of that petition has to be done immediately because she's just wasting time wondering what they're doing. If they've denied the claim already, that's the next step, is to file a petition. You can't get anywhere if you don't file the petition. So I would encourage you to call me offline, and I can help you with that.
Yes. You connect me with someone so we can do that.
Yes. So all you got to do when you get when you get a moment is to give a call to 215-227-2727. You'll give the information to the operator who answers the phone, and Jeff will get right back to you. That's all you have to do. It's simple as pie.
Thanks, Tim.
All right, Tim. Take care. Thanks for calling us. And I bet your wife's happy you reached out to us, too.
All right. Bye-bye.
Bye-bye. Bye-bye. That's it. Folks, do you know what you need to do when you got a legal issue? 215-227-2727. And guess what? I'm coming out with new billboards. I just approved a new billboard design that hits the streets for the holiday season. And contained in the billboard is a message. The message is call 215-227-2727. We'll be right back after these announcements.
For 20 years, Center City Medical Center has provided premium expert medical services for Philadelphia. Whether you need musculoskeletal rehab or an immigration physical, call 888-945-EXAM. Our board-certified physicians have more than 80 years' experience from post-injury rehab to DNA paternity testing. To make an appointment at one of our 3 convenient locations, call 888-945-EXAM. Get premium expert care. Center City Medical Center, serving Northeast, North, and Center City, Philadelphia. If you have legal problems and need answers, call My Philly Lawyer's Dean Weitzman first at 215-227-2727. Whether it's personal injury, medical malpractice, birth injury, or more, Dean is ready to fight for you and the compensation you deserve.
I'm Dean Weitzman. Facing any kind of legal or medical challenge can be overwhelming, but you don't have to go it alone. Call 215-227-2727. My Philly Lawyer, when winning matters most.
If you've been injured on the job and are entitled to workers' comp, you need someone fighting for you from the start. Call Jeffrey Gross, attorney at law. Don't rely on your employer or insurance company to get it right. Call 215-512-1500. If you're entitled to workers' comp or it's being challenged, Jeffrey Gross can help get the money you deserve, and he won't get paid unless you get paid. Call 215-512-1500. Jeffrey Gross, attorney at law, representing Pennsylvania's injured workers for more than 20 years.
If you've been injured, the road to recovery can seem long. At United Therapy Centers, we're here to help. Call us 877-510-7764. With leading-edge technology and our team approach, we provide the highest level of patient care with a pain management program developed just for you. If you've been injured, we can help. Call United Therapy Centers toll-free 877-510-7764. United Therapy Centers, get on the road to recovery.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Welcome back, folks. It's Court Radio, live and in person. And I'm Dean Weitzman, joined in the studio with my co-host, the wonderful Jeffrey Gross.
Yeah.
Workers' comp extraordinaire. We've been hitting some workers' comp questions, but if you've got any legal issues, give us a call at 215-227-2727. Let's start with Susan from that little state to our south, Delaware. Hi, Susan. Welcome to Court Radio.
Good morning. How are you?
We're wonderful, thanks. Thanks for taking the time to give us a call today with your question.
I need some help. I had an accident. Somebody hit me last year, and I thought that, they just pay out and so forth. Doesn't work that way.
Yeah, well, I was just talking about that when you were on hold.
I heard that accident.
Yeah.
And then I had some medical issues, so I just came out of surgery in August, and I'm driving, and September somebody hits me again. So I got 2 injuries going on with the same, pain.
Yep, that's always a problem, too. When you have multiple injuries and multiple accidents and similar injuries, it's hard to tease that out. And, when you've caused an injury, you're responsible to pay for that injury. But when there's confusion over what injury you caused and what injury somebody else caused, it never is a good thing for you, the claimant. But nonetheless,
I wasn't responsible at any time.
I understand, but responsibility is the one part of the question. So it's easy to say, okay, Party A is responsible for the first accident, Party B is responsible for the second. But then the second question is, okay, what injuries did Party A and Party B cause? And you, as the injured claimant, you must prove within a reasonable degree of certainty exactly what pain and what injury came from which accident. And that's where I say sometimes that confusion cannot, is not a friend of the claimant. But in any event, having said that, we have a lot of experience dealing with these types of issues. And I'm shocked you don't have an attorney yet, and especially...
Well, I've actually called, and a lot of them don't take the case. They felt like it was very small, and there was a problem with the police not wanting to do a report. That's a new thing in Delaware, where the police feel like they're adjusters.
Right.
And they say, it's not $5,000, we're not writing a report.
Right.
I've never heard of such a thing. If there's something he's asking me, I'm saying I can't tell a cop what to do.
Right. And, in Philly, if a case doesn't involve towing or a hospitalization, police don't even respond to the scene of accidents any longer. They say, hey, call the police station and report it yourself. So...
Isn't that something?
Yeah, that's the way of the world. And that's why it's important, again, to use you as an example. When we're involved in an accident, we need to make sure we get the name, the address, the telephone number of all parties, drivers, owners, witnesses, and take pictures and do all that you need to document that claim. Because if you leave the scene of an accident and you don't have that basic information and you come to me, who am I going to sue? How do I know who to sue? How do I know which insurance company? So when the police don't respond, the job is doubly difficult for you.
Right. And you're absolutely right.
In any event, listen.
The last one was a hit and run, and the cops never showed up. And I had to chase the lady down. They kept telling me, don't chase her. I said, look, there's no cop here. I know what I got to do. So I got the girl, and I got information, license, and insurance and everything, and still no report. But the insurance company did take responsibility, but I haven't done anything as of yet. All right. So this is what you need to do. Later today, tomorrow morning, you need to give us a call at 215-227-2727. The same number you called for Court Radio this morning. And we'll bring you in right away, and we'll get to the bottom of it. We'll investigate the claims. We'll figure out with your doctors which injuries are related to which accidents, and you'll have competent representation, and you won't be going it alone. Yeah, it's kind of hard, and I'm being chased as I'm speaking. There you go. I got investigators, I assume. They're saying it's not investigators, but I'm not crazy. The police don't help you, so it leads me to believe I'm correct. Well, it wouldn't surprise me, and we're going to jump off the call, and that helps me raise the next issue with Jeff. But thanks for giving us a call, and give us a call during the week. All right. Okay, thank you so much. Take care. You too. Maybe she's crazy, maybe she's not. But let me ask you, on workers' comp cases, have you ever seen people being followed? Oh, all the time. This is one of my favorite pastimes because I love to respond to the people who investigate my clients. When they investigate them, they do it in a number of different ways. Sometimes they look at their trash, believe it or not. Get out of here. Oh, yeah. You would be surprised what's valuable in your trash. Pay stubs. If the workers' comp carrier thinks you're working and they want to prove it, they will have somebody look at your trash because you threw it away. It's no longer your property, right? So therefore, they look at the trash and they want to see if you've thrown away any pay stubs, that kind of thing. But they also investigate by video. They're not allowed to record in Pennsylvania your voice without your permission, but they are allowed to videotape you and your actions from afar. So if they're on the street and you're doing some yard work and they're filming you, be careful. You see a lot of vans out there with black tinted windows where you can't see the driver and you can't see the crew in there either. You got to be careful what you're doing. Don't do anything you're not supposed to do is what I tell my clients. If you do stuff that you say you cannot do and they catch you doing that, that shoots your credibility down big time. And credibility of my clients is the most important thing in front of a workers' comp judge. If a judge is evaluating the case, the first thing the judge is going to want to look at is the credibility of the claimant. And the judge will either like the claimant or not like the claimant. If the judge likes the claimant,
The judge is human. The judge will do everything in his or her power to find in the favor of the claimant, and they will discount certain medical evidence, and they will increase the value of other medical evidence to support that claim. If they do not like the claimant, then they will do the reverse. So you have to be credible, and the way to be credible is if you say you can't do something, don't do it. If you can do it, then just say you can do it. So a lot of people say they can't drive, for instance. If you can't drive and they catch you driving to the supermarket and loading up a cart full of groceries, that's not a good thing. But if you say I can drive, but I can only drive for a limited amount of distance and time, and you support that with a video that's surveilling you, then then that's not so bad. Then it shows that you can do what you said you can do, but you can only do it for a limited period.
See, the thing with workers' compensation is it goes on forever, and therefore there's a financial incentive for the insurance industry to spend the money to surveil the claimants, because otherwise it's a big ticket item for them.
Here's the good news. If you're being surveilled and investigated by the workers' compensation carrier, that means your case has merit to it and has value to it. It costs a lot of money for an insurance company to do that kind of an investigation. They have to send out a crew of videotape professionals and videographers and drivers, and they have to be on your tail basically 24/7 until they catch you doing something untoward. And if they're going to be watching you, chances are they're going to be watching you for a long time before they catch you doing something. I had a guy that was under surveillance for 9 months, only to catch him doing something for 1 day. One of the best things that I like to do in the surveillance aspect of what I do is to cross-examine these investigators as to how long they've been tailing my client. Because if they've been investigating my client for a year and they find 1 day of bad stuff, that doesn't look too good for them. It shows that they maybe have tried to do something and maybe they hurt themselves even further doing that, just to test to see how far they could do. People are human. The judges realize that. So that when the judges see videotape, they become actually suspicious. They don't say, aha, they gotcha. They become suspicious because they realize the cost of the investigation in the first place.
If you got legal issues, we're the people to give a call to this morning. 215-227-2727. Let's talk to Bob from Sharon Hill on line 4. Hey, Bob. Welcome to Court Radio.
Hey, good morning. Good morning to your guest.
Thank you so much.
Hey, I got a question here. Like, as far as a construction worker, when he gets hurt on the job and they ask you, or however they do it, say you return to work and you'll keep getting paid, not to go and work this comp. But then when the job is over, he gets laid off, and now they don't want to pay him no more. Should he still try to get workman's comp?
That's a very, very good question, Bob.
Bob always asks good questions.
I'm telling you, that's a really good question. That's a little dirty pool that's being played by the employer. You see, if they pay him salary in lieu of compensation, which is what you're describing, because they don't want to put him on workers' comp, and yet he doesn't have to do the job 100%, i.e. he's either doing it light duty, or they're even maybe having him sit in the office really not doing anything but paying him his full salary. What that does is that it obviates the need for workers' comp. They don't have to pay the workers' comp in that regard. But the minute they lay him off, Bob, that's when the workers' comp will go into effect. And what I would encourage all people to do is to get in contact with me the minute they have the injury, because even though they're paying wages in lieu of comp so that they don't have to pay workers' comp, I like to file a claim petition anyway to protect their interests. And when I do that, what happens is it holds the comp claim in abeyance, and when they stop making that payment and they lay him off and he can't do the job, that's when the workers' comp will kick in. Otherwise, you have to start from ground zero as of the time he becomes laid off, and that takes a while to get onto the system. So the answer to your question is, early and often, contact a lawyer, call me. I can file a petition immediately, and then when that person gets laid off, there will be a smooth transition to workers' compensation in a timely fashion, which is really important because you got bills to pay, and by getting laid off, you're not getting paid. The only recourse after you get laid off, if you're not getting workers' comp, is to apply for unemployment compensation, which is probably what you think you should do. But when you apply for unemployment compensation, that acts as an offset against your workers' compensation benefit, and at the same time depletes your entitlement to unemployment compensation in the future. You only have a certain amount of unemployment compensation you can have, and when you use up all your credits, you use them all up. So you want to preserve those credits and not use the unemployment compensation if you don't have to. So if you're laid off, folks, light duty, if you're on light duty and you can't do your job, but they then lay you off because the job's done, you're entitled to workers' comp immediately.
There you go. So Bob and people like Bob should call us at 215-227-2727 if those circumstances apply to you. Bob?
Yes.
Did that answer your question, Bud?
Yes, sir. Very, very, very good.
There you go. All right, we'll see you on the next question. Take care, Bob.
Take care.
What was that? Oh, yeah, you can call always. Bob can call Jeff. Yeah. Bob should call Jeff. Bob knows to call Jeff. Bob is a court radio adherent. Bob calls 3 times a day with questions.
Love Bob.
Yeah. Bob from Sharon Hill. Okay? I'm going to get T-shirts made. Bob from Sharon Hill. All right, let's talk to Christine from Northeast Philly on line 5. Christine?
Good morning.
Good morning. How are you? Sunshine, you sound so happy.
I have a quick question for you.
Yes?
I'm on salary, and I am being required to work over 60 hours a week for the same pay. At what point is overtime come into play, or can we make you work 80 hours a week without extra money?
Is this a work-related injury, or are you just not getting paid overtime?
I'm just curious what the law is regarding that.
That fits. Yes, that fits under something called wages and hours law, and basically, if your salary, then there is no overtime. If you're making a salary, meaning this is what you get paid for your job, there is no such thing as overtime because you're just getting a lump sum of cash over the course of a year divided up into 52 weeks or 26 weeks if it's every other week, and that's what you get. If you're an hourly rate employee, on the other hand, and you work over 40 hours a week, then you should be entitled to what we call time and a half, which is 1.5 times what your regular rate is for hours worked in excess of 40 hours. Now, there are exceptions to all of this stuff. If you're an over-the-road truck driver, it doesn't count because they don't want you to work overtime. They don't want you to fall asleep at the wheel and get into an accident. So there are exceptions to the wages and hours law. If you're working on a salary basis, though, there is no overtime.
Okay.
Thanks, Christy. Take care, dear.
Have a great day.
You too. Have a great holiday. 215-227-2727. Folks, we've been knocking it out of the park, so we're going to take a quick break. And if you've got questions you've been sitting on, now's the time to give us a call at 215-227-2727. We'll be back in 2 minutes.
If you've been in a car, truck, or motorcycle accident, you know what matters. Being able to afford medical care, providing for your family while you're out of work, knowing your rights, and getting just compensation. These things matter. That's why your attorney matters. I'm Dean Weitzman. If you've been injured in a motor vehicle accident, My Philly Lawyer will fight for you. Call 215-227-2727. My Philly Lawyer, when winning matters most. If you or a loved one has been the victim of a medical mistake or misdiagnosis, you know what matters. Getting proper care matters. Providing for your family matters. Your attorney matters. I'm Dean Weitzman. For more than 30 years, My Philly Lawyer has been holding hospitals and insurance companies accountable for medical errors. Let us fight for you. Call 215-227-2727. My Philly Lawyer, when winning matters most.
You were just hurt. It's not your fault. You're in physical pain. How do you get better? Who is going to help you recover? West Philadelphia Associates has highly trained doctors and staff that can help you today. Don't wait at a hospital. West Philadelphia Associates will work with your attorney, providing documentation of all injuries and the best plan for treatment to get you back to the life you deserve. With diagnostic studies to better detect injuries, West Philadelphia Associates doctors and staff will help you recover. West Philadelphia Associates, here to help you get better because you deserve it. Call 215-471-4714.
For 20 years, Center City Medical Center has provided premium expert medical services for Philadelphia. Whether you need musculoskeletal rehab or an immigration physical, call 888-945-EXAM. Our board-certified physicians have more than 80 years' experience from post-injury rehab to DNA paternity testing. To make an appointment at one of our 3 convenient locations, call 888-945-EXAM. Get premium expert care. Center City Medical Center, serving Northeast, North, and Center City, Philadelphia.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Welcome back to Court Radio. Court Radio listeners, it's Dean Weitzman, and I'm joined in the studio with Mr. Workers' Compensation, Jeffrey Gross. Jeffrey S. Gross.
Yes. S for Scott.
S for Scott. This past week, Jeff and I had a reason to join ourselves up in the Northeast office to do a sign-up and to meet with clients who were involved in an accident. And the accident actually had a workers' comp component to it. He was in the course and scope of his employment at the time. And there was a third-party case, which is what we do at My Philly Lawyer. You know, we represent people against the bad people who cause injuries. And Jeff makes sure that if that happened during the course of your employment, that you get your full salary and all the medical bills paid. And eventually, a settlement. But we have a Northeast office as well as the Center City office, and so if you're up in the Northeast or Bucks County and you want representation from My Philly Lawyer and you don't want to schlep down into the city, no need to come down to Philadelphia. All I have to do is send a team of people up to the Northeast office, which is staffed by attorneys and paralegals anyway, and we can meet you up there. And that's, right up on Bustleton Avenue in the greater Northeast. So fret not, you will not have to pay for parking. I have plenty of parking in the Northeast office for free. 215-227-2727. Let's talk to John from Wilmington on line 2. Hi, John. Welcome to Court Radio.
Hey, good morning.
Good morning to you, sir.
Yeah, I'm calling with a question about an auto accident.
Okay.
My fiance, she totaled my car. Okay, but I got 2 policies from two different insurance companies for coverage. The agency that I went to, they set up one policy from one agency called Impact Insurance, and when I went back, they had another policy from Dwayne Ball Agency. The first policy was effective 8/15/2015 when I went to apply for the policy. Okay, I went back the next month to pay my next payment, and she gave me another identification card with starting from 9/8/2015 and didn't expire until 11/9/2015. Okay, my car got hit on the 1st of November. When I went back, they said I didn't have no insurance. However, I got another policy from Harleyville Insurance, full coverage insurance, from Dwayne Ball Insurance Company. So now what they're saying is that I didn't have insurance. I understand that my car was totaled and it was my girlfriend's fault. But I paid to this insurance company for full coverage insurance, and both companies sent me policies of full coverage. Okay. When I went back to the insurance company, I said, well, listen, if I don't have insurance, then just pay me back my money that I paid into my insurance. The guy did that willingly.
Whoa. Why would you ask for your money back? How much was that car worth?
Well, it was a 1999 Sea Breeze.
Oh, okay.
But I asked my money back because my money wasn't. I thought my money wasn't getting appropriated to the places where it needed to get appropriated to.
Yeah, but if you ask for it back and you get it back, then in essence you're agreeing that there's no coverage for that claim. You don't get your money back and get to make a claim for coverage under a carrier's policy. So once you ask for the money back, then you're giving up your right to claim for that policy. Go ahead.
Okay, check this out. I rode around to August to November thinking I was covered.
And you weren't.
I didn't get my money back until after my car got tire spiked.
Right.
When I went back, they told me my car wasn't covered. But I've been riding around since August.
What's the question?
My question is, who can I go after to get my car fixed?
Well, first of all, if I could undo what you did, I would have left that money on the table for a minute till you figured out who owes you coverage. The simple answer to your question is, for a 1999 car, I would imagine you could have filed a small claims complaint or a municipal court complaint on your own against both insurance companies. Let them hire lawyers and come in and tell you don't have coverage. And I would have sued the broker on top of it. So I would have sued both insurance companies and the broker and let a judge figure it out. But if you've got proof of payments, the burden would have been on them to show why you don't have coverage. One of them would have been responsible, no doubt.
Tell you why he didn't have coverage. He told me that the person he had working there for him was still on the money. He wrote that on.
Well, you know what? That's his agent, and that's his problem. And therefore, again, I say, I wouldn't have taken the money back. I would have sued the broker and both insurance companies and let God sort it out. But that's probably off the table now that you took the money back. But maybe for the next time, that advice.
Okay, I understand what you're saying. But do you understand what I'm saying? I drove from August to September.
Yes, but you didn't have knowledge of the fact that you didn't have coverage. And so, I don't fault you for that.
No, I do have knowledge of the fact that because I was sent to policy.
No, you didn't have knowledge of the fact that you didn't have coverage and that there was a problem with the policies, so I don't fault you for that. And yes, you were driving around for a few months without coverage. Supposedly, if you believe the agent that the money was stolen by some employee. But, again, the simple answer is when you have problems with people, you need either legal representation or at least to give us a call for me to say, hey, do this in small claims court. Do this in municipal court. You can't afford to have an attorney get involved in this case, but you can do it on your own. These courts, these smaller courts, are set up to help claimants through this process who can't afford representation for these minor claims. John, thanks for giving us a call on Court Radio. Have a great Sunday and better luck on the next coverage issue. Let's talk to James from Chester County. Hello, James. Welcome to Court Radio.
Yeah, how are you today?
We're wonderful. Happy holidays to you, James.
Same to you. Thank you.
Mm-hmm.
I have an issue. I was in a car accident a year ago and did seek counsel. And, in fact, I've met with counsel. And the problem is that my correspondence with counsel, when I'm just trying to get an update on is there any progress in the case or on the case. I was hit from behind. My car was totaled. I was injured.
Let me ask you a question. Let me just jump in for a second. So you're not getting any communication with counsel, and you're wondering what it is you need to do to get him to respond or to move on to somebody else.
Correct, because here's the issue at hand is that I've completed my therapy, and the person told me that they were seeking information on my PIP ledger and things of that nature. But this is the same thing that you said to me about 4 or 5 months ago.
Right.
And I don't know. I mean, you're kind of sounding redundant and as if you're not even really working on the case at all. Okay.
So here's the tip for people who are in this situation. You're not married to a lawyer, okay? The representation is a contract. I'm not minimizing that, but it is not. It doesn't happen every day. But once in a while, a client and a lawyer it doesn't work. The relationship doesn't work. You're not getting what you thought you were going to get, and you want to sever that relationship. And it's easy. You go to another lawyer. And you say to the other lawyer, hey, here's my case. Would you look at it? Would you possibly take it? If the new lawyer takes the case, he or she will work some equitable arrangement out with your old lawyer. The old lawyer is discharged. He no longer has the right to represent you. And you move on to greener pastures. And it's that simple. Okay. All you got to do is call another lawyer, okay? And that's what happens. If you have further questions about it, give us a call at 215-227-2727. James from Chester County. Now, let me just real quick. Are you full or limited tort? Do you even know what that is?
I do. And because the vehicle was not my vehicle,
you're full.
So it's going to be full tort.
Okay. That's all. So, it isn't like, because sometimes lawyers will take a limited tort case and then they'll review the medical records very closely after the person has been done treating to see if they if they do have a permanent and serious injury. And if they don't, then they sever the relationship. And I was just wondering if that might have been the circumstance, but it isn't.
If you don't mind me interjecting, I do want to say is that I did injure my back, and since I've had injections done on my back.
Sounds like a serious problem. It sounds like you should have. Yeah, it sounds like you should have better communication with your lawyer. If you're involved in an accident and your injuries are so bad that you're getting injections, then this is not a small case any longer. It's a case that deserves careful attention and careful communication between the lawyer and the client.
Correct, and I believe that. 100%.
All right, Jimmy or James from Chester County. James, by all means, give us a call during the week at 215-227-2727.
Will do, and God bless you.
God bless you. Take care, James.
All right.
All right, let's talk to Terrence from Elkton, Maryland. Is that Elkton, Maryland? Or wow.
Yes, it is.
I thought people only went there to get married, like youngins, like they climb down the ladder when, they're 16. They can't get married in Pennsylvania, so they run to Elkton, Maryland, who will marry anybody and everybody.
Absolutely.
All
How
right.
are you doing today, Dean?
I'm doing well, Terrence. What's your question? We got limited time left.
Very quick. Just it's not a workman's comp question, but my daughter was in a car accident back in August. And when she has an attorney, but when she went to file, they did the file for her lost wages through the insurance company, and because they said that, I want to know, is there anything she can do with the employer themselves, because they took her off the schedule after she was when she reported the accident to them. She was on her way to work, and she reported the accident. Then they took her off the schedule, and so they said because she wasn't on the schedule, they couldn't pay her lost wages because the employer took her off the schedule.
Okay. Well, most employees are employees at will, and employers can let them go for any reason at all. If she was not injured in the course and scope of employment, then it becomes just an employment issue, and most people don't have many rights when it comes to their employers putting them on or taking them off the schedule. However, the bottom line is if she's physically unable to work and she has coverage for wage loss in that auto accident, then whether she's on the schedule or not, she should collect her lost wages. In fact, I've collected lost wages for clients who weren't even employed at the time of the accident because I've been able to prove that they had a good chance of becoming employed, but that chance was deprived from them because of the injuries sustained in the accident. So employment isn't even necessary in that circumstance. But I'd love to talk to you further. We got to run. It's the end of the hour. God bless. Happy holidays. We'll see you next Sunday. Jeffrey, thanks for being